Okay, so here's a story I actually talked about last night a little bit on stream. This is a story about Pokemon and its patents, as you can tell from the title. This is a patent that has a parent patent that might be in question and a child patent, which will definitely be in question. So, Japan Patent Office rejects Nintendo application relevant to Palworld's dispute. Cites games like Arc as prior art after third-party submission. That third party probably being Pocket Pair because it will affect their court case. Um, Lawyers or judges really like bringing up patents and following those patents. In this case, they now have a patent that was changed mid case and now another one that's getting denied. So this is getting like really bad on Nintendo. So Nintendo's patent infringement litigation against Palworld maker Pocket Parry is still ongoing. It may be part of a PR strategy to distort the reality of who was the first to create what, given Nintendo itself is apparently developing a Pokemon spin-off with Palworld-like elements. We actually saw this in Pokemon ZA. Pokemon ZA went 3D, and that 3D is pretty bad. I mean, really bad. And it's pissing a lot of people off. I know that they're actually having some refunds as well. So we're not exactly sure on what the sales are, and are they going to remove the refunds from the total sales? I doubt it. So a decision called office action, that's just any final decision, made by the patent examiner of the Japan Patent Office, so not US, this is Japan, less than 2 weeks ago. Like I said, this was, of course, told to them on October 17th. So it cast doubts in the validity of two of Nintendo's three patents in suit. Those are the ones being used against Palworld. It gives a number here, 2024 03 1879. The 2024 is in fact the year, and this is a split off of a parent patent. So even though it was submitted after their arguments, it's still really the 2021 patent. And that's why they call it later on, the games that predate Nintendo's December 2021 priority date. That means that those are the dates that they're basically going by as to what would be prior to Pocket Pair's Palworld design. So, unfortunately for them, they have several examples, some funnier than others. Nintendo Studio Wildcard's Arc, Capcom's Monster Hunter 4, of course. Pocket Pair's Craftopia, of course, that's what they're trying to argue in court. A Japanese browser game named Kantai Collection, that's the Ship Girls. And Pokemon Go. That is not a mistake. The reason why they can bring up Pokemon Go is because Nintendo actually hired somebody else to make the game for them, as they do with everything else. So, that's their prior art. They would have had to go to them to get approval to add a function from Pokemon Go into Pokemon ZA or any other future game that they're going to bring out. So, this is that they're going to go into a little bit later, but this is the argument that they think they own the right to throw a ball, have a monster pop out of the ball, and start fighting an enemy. That's what this patent was for. Like I said, we're going to go into it, but let me just go over this real quick. Just like the applications that led to the patents in suit, this application was filed shortly after Palworld's release. Yes, that's a thing. Yes, that's important. But it doesn't invalidate it because it is a child of that patent from 2021. So, we're not going to go over the rest of that. That doesn't really matter. It's a lot of like legal speak and, it's non-binding Nintendo Free Pocket Pair case. That type of stuff doesn't really matter. We're just talking about the patent here. And then they have this. If you look right here, it is highlighted a little bit, but it's not done very well. So what I did is actually highlight it for you. So that number that I mentioned above, that 031879, that's the one that you saw before as the one that was denied. You see there's the two dates there and their numbers. Look at all the others. Below those, there's a number. On all of those, that's basically the approval number, including their child patent from the failed one. That's why this is important. It's going to possibly invalidate this, depending on what was taken from this. If it was something that was brought up earlier, like something that was in Ark, something that was in Pokemon Go, that will invalidate this. It will be looked at with scrutiny. But they also might be looking into this patent up here, where the one above it was split off into the three that you see back in 2024. And so those might come into question. Is something in that patent possibly prior art as well? They'll go back to that. So let's get that off screen so we can keep going here. So you see the application 031879, and it stems from the application of 2023 204842. That's the one that was right above it. And then ultimately granted, they say JP 7505852. And that is the number that you see below it minus the JP. So that is your approval as of the date. Yeah, that they approved it, plus probably another 18 months before, or a few months before this, but that already took 18 months from apparently 2023 sometime. This is 2024, and they didn't even wait for that to get approved. And now we're down here for one that was approved. So that's where they talk about giving birth to. And then they bring up the 149570, that's that one down here. So ultimately granted, so that one was granted, which is equally being used against Palworld. So keep all that in mind. This is the stuff that's being used against Palworld. This was denied. This now comes into question, and this might come into question as well. All this based around throwing balls at enemies. And a monster popping out of it. That's it. Now, it doesn't specify anything more than a pod. So, that is generic enough that if you were to make a game that had a cage, they could argue that that's a pod as well. That is how generic this is. You usually want to add for generic, but that is way too generic. If they wanted to describe something that was very specific, they could say that it's a ball that shines light when it opens, and a monster appears, and it describes a function. Maybe they can do that, but at that point, it's a copyright, not a patent, because it's based on design. And they're going after Palworld, or Pocket Pair in general, with a patent. That means that they're going after the function of what it does. So I'm just going to go over this real quick. This application should be refused for the reason mentioned below. If the applicant has any questions against the reason, a written opinion should be submitted within 60 days from the date on which this application was dispatched, which was this date right here, October 17th, 2025. they won't be waiting that long. They're in court, in and out of court with Pocket Pair now. Plus, once they send that, it's going to take time for them to look at it and remake their decision however they do so. Now, the reason is called the inventive step. Keep that in mind when you're talking about any patent or any copyright, is that it has to be novel, it has to be new. It can be slightly based on something that might be natural, but you can't have a game where you're walking and then patent running, because that's an obvious next step. And that's what they're bringing up here. In a more wordy version, run could have easily been made by persons who have common knowledge in the technical field to which the claimed invention pertains. Now, this doesn't only necessarily mean a game like technical knowledge. It could be the concept as well. So, like I said, with the running, with the argument that they're trying to make with the animals, where you can start flying on the animals or holding on to the animals, and they had to change it to a glider. And that's because they wanted to copyright the fact that you can ride dragons. Hundreds of years old stories already have flying dragons and knights on top of them. They cannot do that. And they're going to argue that these are monsters of some sort, and those are like something different in some way. Don't let them get away with that. So, see in particular video time, and then they gave some times. This is a video that we do not have access to. That is one of they gave the patent office. I'm assuming Pocket Pair is the one that gave it to him. So they gave it to him, and it is the game Ark. That's what I was talking about before as far as the games that they're referring to. This one is Ark. And so it describes an invention relating to a game program in which the game Ark, the relative positional relation between the aiming of a blue cross displayed in the center of the screen and the enemy character is adjusted by moving the angle of view. A pod directed to the aiming direction and thrown by a human-like player character, a dwarf-like battle character appears from the pod, and a battle between the enemy character and the battle character is started. Basically, they tried to patent throwing a ball in the direction of crosshairs by using a joystick to aim. And then, out of the ball comes a small monster that starts attacking another monster. That is what that says. That is the argument that they're making. That is not novel at all. Not in the slightest. I do not know why they're making this argument. It is going to backfire on them, and it's going to piss a lot of people off. And then the failure of the last two Pokemon games to make the kind of money that they expect as investors, because let's face it, it's mostly investors that you're looking at with this. As investors, they're being told, oh, this is going to make like 1 billion sales. And it makes a tiny fraction of that. They're going to be like, maybe I'm not going to put money towards this next game. And maybe if you keep acting like this, I'm going to sell your stock too. So that's where they have to start being worried. Now, I just go here to document 2. It describes that an enemy character can be attacked by using various weapons in a game called Ark. So again, they bring up Ark. And when the descriptions, a tool that can be used to cause coma. How to use a bow are combined, and is deemed that cited document 2 describes a parameter called the coma value. So basically, attacking a character enough so that they become capturable. And they just call it coma. but any sort of knockout type status to where you can capture it, a character, monster, person, whatever. That's what they're trying to argue here. And then further down, they go into just more wordy descriptions of just that. Literally, all of this is just this. That's it. And then they talk about a pod thrown to the player character in the aiming direction. A dwarf battle type character appears from the pod. A battle between the enemy character and the battle character is started. So again, that's just repeating what's up here. And that's really wording out in legalese. I threw a ball and a tiny character that attacks another character popped up. That's it. That is their argument. Further down here, they noted something else, and I'm just going to go over it real quick because the rest of this is citations and legalese. So, they are talking about writing characters. And so, they go into, in a technical field of games, that a battle with enemy characters, it's well known that a predetermined gauge is reduced by winning a battle with a boss. And an in-game event can be cleared by cutting off the gauge. That's your health bar. And then they go into a method for reducing transport gauge. That is called a stamina bar. That has existed for a long time. And they call it a transport gauge because they want to try and use this against them for having a stamina bar for flight or writing a character or something. They cannot be allowed to have that because, like they said, it's something that has happened before in another game. And that's where you go up to their whole list of games up here. With Monster Hunter 4, it's probably more what they're referring to in that one, but Pocket Pairs Craftopia, Japanese browser Konkole, and Pokemon Go. So, keep all this in mind. This is such gaslighting. And I'm going to go back to one thing that they said here that I think is important, and that it's a PR strategy to distort the reality of who was first to create what. I think this is the entire point of this. It's not to prove that they created it, it's to cast doubt in who did. Because if they can muddy the water so much, they might be able to beat Palworld with something that they shouldn't even have. Keep that in mind. This is going to turn into a huge mess now that they just lost this. Have a good one.